Thank you very much for joining us. I see there is currently more than 600 people. It's an honor and a pleasure to have you here. My name is Elena Pribytkova, and I'm a Senior Research Fellow at the Center for International Law, National University of Singapore. Our webinar is devoted to the right to peace, which is recognized as both individual and collective human rights in a range of international instruments. It is also recognized at regional level. For example, ASEAN human rights system acknowledges an individual and collective right to enjoy peace, while African human rights system also recognizes collective rights of peoples to national and international peace. At the domestic level, provisions relating to human right to peace, as well as some guarantees of its judicial protected, have been recognized in several states such as Japan, Congo, Ecuador, Colombia, Bolivia, and some others. At the same time, the sacred right to peace, as mentioned in the Declaration of the Right of Peoples to Peace, continues to be one of the least developed and most neglected human rights. Over 120 armed conflicts unfolding worldwide highlight this, and also highlight violations, continuous violations of the right to peace by states and non-state actors. There is still no consensus among scholarship and practice regarding the nature, status, content, scope, corresponding obligations, as well as duty bearers of the right to peace. I hope this webinar will contribute to filling this gap. And its three fundamental goals are: first, to analyze the history of the struggle of the human right to peace. Second, to explore contemporary approaches to interpreting, institutionalizing, and implementing the right to peace in international and regional law. And finally, also, I think, to propose ways to advance the right to peace as universal, high priority, claimable, and enforceable legal entitlement. Let me introduce our wonderful participants. I will start with Cecilia Marcela Bellet, who is a UN independent expert on human rights and international solidarity. And her latest report is, by the way, on peace and international solidarity. She is professor at the University of Oslo and has published extensively on public international law, human rights, solidarity, and peace, including her books, The Construction of the Customary Law of Peace, Latin America and Inter-American Code of Human Rights. Another book, The Research Handbook on International Law and Peace. And finally, Promoting Peace through International Law. Thank you very much, Cecilia, for joining us. It's a real pleasure. Professor Surya Deva, who is UN Special Rapporteur on the Right to Development, and he's currently working on the report Peace for Development. He's also professor at the Macquarie Law School in Sydney. He is a former member of the UN Working Group on Business and Human Rights. And he is an exceptional expert in international human rights law, business and human rights, sustainable development, climate change, and gender equality. He is also one of the founding editors-in-chief of the Business and Human Rights Law Journal. Surya, thank you very much for joining us from New York. It's a pleasure. Professor Elen Tigruja, who is a vice chair of the UN Human Rights Committee. She is my colleague and a visiting research professor at the Center for International Law, National University of Singapore, as well as professor of public international law at Omar Sy University. She has published extensively in human rights, international law, and European law, including the co-authored commentary of the American Convention on Human Rights and a treatise of international human rights law. She has acted regularly as an expert for Council of Europe, UNESCO, and European Union. Dr. Padamoyo Mukumbiri. Dr. Padamoyo Mukumbiri is a lecturer at the Southern and Eastern African Regional Center for Women's Law at the University of Zimbabwe and adjunct lecturer at the University of Nairobi, Kenya. Her research and teaching interests are in the areas of human rights, gender, and law. She defended a dissertation titled An Analysis of the Implementation of Women's Rights to Peace by the African Union Peace and Security Architecture, a case study of Zimbabwe, at the Center for Human Rights, University of Pretoria in South Africa. Within the Zimbabwe Women Lawyers Association, she has facilitated training programs on gender and law for different stakeholders. It's a pleasure, Paida and Hélène, to have you here. And last but not least, my co-moderator, Dr. Maria Varaki. She is lecturer and director of the Master in Peace, Security and International Law at the War Studies Department, King's College London. She is also a research associate in European Research Council's project, Three Generations of Digital Human Rights. She publishes extensively in international law, peace and security, and she has worked for the Office of the UN High Commissioner for Human Rights, the Office of the UN High Commissioner for Refugees, and the Office of the Prosecutor of the International Criminal Court and The Hague. Thank you very much, Maria. It's a pleasure. So let me briefly tell you about the structure of our webinar. After this introduction, we will have presentations by participants. I kindly ask to use no more than 5 minutes for each presentation, followed by about 30 minutes discussions, and then we will proceed with Q&A session. I would like to encourage our audience to send us your questions and comments. We will do our best to respond and to address them. And finally, there will be closing remarks. I would like also to express our sincere gratitude to our director of the Center for International Law, Niloufer Oral. She unfortunately cannot be here. She is now in Geneva. And to our wonderful CIL events team led by Jerry. Thank you very much. So now it's time to proceed with our short presentations by speakers. And Cecilia, may I please give floor to you?
Welcome. Thank you very much. You asked me first to address my book on Latin America, the construction of customary international law of peace and the Inter-American Court of Human Rights. So the book sets forth that peace is a Grundnorm that has been universally recognized in all legal systems. It is normally unique because it's both an end and a means of the legal system. One can only achieve peace through pacific means of dispute resolution. So the book discusses the history of the articulation of peace as a regional value within Latin America that declared itself a peace zone ever since President Roosevelt came to Buenos Aires in 1936 to hold the first ever joint radio broadcast in the region to promote allegiance to peaceful dispute resolution and regional rejection of the catastrophe of war that was plaguing Europe at the time. I then examined the constitutional iterations of peace within the Latin American constitutions, evincing a tension between peace as an aspect of peace, state control of society, given the requirement that assembly be peaceful, as opposed to examples in which peace enables societal emancipation, for example, through promotion of a culture of peace. And several constitutions recognize an obligation of externally oriented peace, such as participation in peace missions and even peaceful passage through the Panama Canal, as well as renunciation of war or prohibition of foreign military bases. In contrast to the view that peace is not justiciable, there is really rich case law within Latin America at the national level. For example, the case law from the Colombian courts relating to the Constitution's recognition of peace as being both a right and a duty of both the state and society. And Ecuador and Costa Rica also have relevant peace cases. And finally, I studied the contribution of the Inter-American Court of Human Rights promoting positive peace, that's non-discrimination and equality, through its correction of state repression of peaceful protests to non-repetition orders on equality and non-discrimination. And now turning to my recent report on peace and international solidarity, I commence with the concern that peace is very threatened at present by the excessive level of militarization around the world and the concurrent reduction in budgets for healthcare, education, human rights, and development. These are the elements of positive peace. And I highlight that there's a paradox given the expansion of transnational organized crime that's prompted governments to declare states of emergencies based on the alleged constitutional duty to guarantee internal peace and public order. But these states of emergency are running over long periods of time, and we're concerned that there are violations of human rights. We also note that states are increasingly curtailing freedom of association in cases where Solidarity for Peace actors are accused of engaging in non-peaceful actions without sufficient evidence. And the report goes on to address the right of conscientious objection and the right to asylum for conscientious objection as crucial elements of the right to peace. The report is very concerned about the lack of funding for peacekeeping and also the withdrawal of states from arms treaties such as the Convention on Anti-Personnel Mines, as well as the regression in nuclear arms control. And most significantly, I call on states to implement Article 7.4 of the Arms Trade Treaty to audit arms transfers to prevent gender violence. And we see all around the world that this is not being implemented. We witness essentially a waging war against women and children in Sudan and in other countries. We have collectively failed as an international community to ensure that women and children around the world enjoy their right to peace. I highlight the role of refugees as peace activists, and I also note the rise in disinformation and polarization and hate speech that's spreading anti-Semitism, Islamophobia, misogyny, and racism. So I call for implementation of the Rabat Action Plan as a means of promoting peace internally. I look at the participation of vulnerable groups in transition to peace processes, and I highlight their efforts at horizontal peace building around the world in many efforts that are actually led by women. I do highlight, however, that the levels of interpersonal violence, including domestic violence and child abuse and suicide, are actually far above the levels of intercommunal violence around the world. So I think as an international community, we need to reevaluate our focus in terms of safeguarding, again, peace for women and children in the home. And finally, the report promises the importance of peace education to break the cycles of violence and truth commissions for truth as an aspect of peace. Thank you.
Wow, even earlier. Thank you so much, Cecilia. But we will have more time for discussion. Thank you so much. May I ask Surya you to join us and to proceed with your initial presentation. Thank you so much.
Thank you very much, Elena, and it's really a great pleasure to join from New York, where most of the discussions around peace and security takes place. And it's a very timely event, and as we can see, more than 600 participants. That shows that the appetite for peace is very much there in the world, despite the theater of the conflicts that we are witnessing, unfortunately. So in my brief remarks, I would like to focus on three aspects. First is I would like to mention the ASEAN context in which the right to peace is recognized in the regional conventions there. Secondly, the implications of this human right. And thirdly, briefly touch upon the report that I just finished writing for the General Assembly in October this year. So if you look at the ASEAN Declaration on Human Rights of 2012, Article 38 very specifically talks about right to enjoy peace. So it's not merely a right to peace, but people should be able to enjoy it. And I think that is significant from my perspective. But also this provision also talks about the other key elements, which is security, stability, neutrality, and freedom. Sometimes neutrality is needed to ensure peace, but sometimes you also need intervention to ensure peace. But at the same time, freedom is crucial. So we should, and I think that's where I will build on what Cecilia was saying, the element of positive peace, that we should not see peace merely absence of violence. Last month, I was speaking at an event in Sydney at the Model United Nations. And a student asked me a very important question, that can we see that there is a peace in Afghanistan because Taliban has taken over and all that. And my reaction was that peace is not merely absence of violence. If women and girls in Afghanistan are not able to exercise their basic human rights, then we cannot really consider the situation as a situation of peace, in my view. Now, more recently in the ASEAN context, the article, I think it's paragraph 2 of the Declaration on Right to Development and Right to Peace, it talks about the complementary and linked nature of right to development and right to peace. This is very clear in international instruments as well. We can refer to the UN Charter. We can talk about the more recent Pact for the Future and other international instruments that document this. Now, what does this recognition mean at the ASEAN level? I would argue that to operationalize these declarations, it is crucial that we have right to peace incorporated in the constitutions. We have in Asia the Article 9 of the Japanese Constitution. There's a historical context for that. But this article provides a concrete precedent how states in ASEAN or Asia generally can incorporate a right to peace as a human right in the constitutional document. But then the question is about the implications. As Elena rightly mentioned, this right is seen more in relation to as a solidarity right. It has a collective dimension, which is very strong. But we cannot say that it has merely a collective dimension. So I will suggest this right has a both individual and a collective component. From my perspective, this right imposes an obligation on both states, but also non-state actors. And those non-state actors will include, of course, companies, but they may also include some rebel groups. Now, peace is needed, but often we have conflicts, and conflicts undermine peace. So conflicts in my report I see as a disruptor to peace. Now, conflicts impact human beings differently. Children, women, minorities in particular, they are impacted more by the conflicts. So when we talk about the elements of this human right, I would say intersectionality will become relevant from that particular perspective. The other element is participation. Active, free, and meaningful participation is a key component of right to development. So, in my view, we have to have participation of people, and that also matters from a taxpayer's perspective. Often, wars and conflicts are fought by the taxpayers' money. So, taxpayers have a right to demand from their respective governments, do we really need this conflict? Do we really need this war? And who is benefiting from this? So these are the legitimate questions citizens should be able to ask the government through a political process, but if needed, through judicial intervention as well. Now, very briefly, finally, about my report. So my report is talking about peace as peace for development, and it will articulate that the world needs to move away from war economies to a peace economy. And as part of that peace economy, the report will articulate a roadmap with four components. Foundational component, for instance, we need good governance, we need to realize the dignified life for everyone, we need rule of law, all these basic conditions. The second is the preventive component. Preventive component is how do you prevent conflicts and ensure peace and sustain peace? That's where diplomacy becomes quite critical, for instance. Then we also need, thirdly, institutional component, which is the reform of the Security Council is very crucial. And the fourth element is deterrent component, where you of course need an approach of collective security in my view, because there are always some rulers who will breach international norms and attack other countries. So to take care of those situations, we need to spend on collective security rather than the security and armies of each and every country. So these are my initial remarks. Thank you very much.
Thank you very much, Surya. Very insightful. Paida, may I kindly ask you to proceed and present your part of contribution? Thank you so much.
Thank you very much, Dr. Elena. This morning, I'm going to talk about the approaches to governance and implementation of the right to peace within the African Union human rights system, particularly looking at women's rights. This is stemming from my doctoral thesis, which I did with the University of Pretoria, where I looked at how the African Union peace and security architecture is implementing the right to peace. I think what is important to note is that the African human rights system is one of the systems that fully recognizes peace as a human right, right? Under Article 23 of the African Charter and under Article 10 of the Women's Protocol of the African Charter. But my analysis of how peace is captured within the African human rights system is that, firstly, it is captured as a collective right, more as a collective right than an individual right, although individuals can claim the right, but it's captured more from a very collective rights, particularly if you look at Article 23, which says all peoples, and even Article 10, which says all women as a collective group that are supposed to enjoy the right. I also have a problem within which the right to peace itself is framed within the African Charter. It is framed in a minimalist approach in the sense that it looks more, it pays more attention to negative peace, as my other colleagues have already said, the absence of conflict. And when you look at conflict, the conflicts that I'm talking about are the conflicts related to armed conflicts, right? Yet conflict is something that is very broader, something to do with unequal distribution of resources, which might not necessarily result in armed conflict. So from the African perspective, my view is that peace is viewed more in militaristic perspective without looking at the other aspects of peace, positive aspects of peace. So under the African Human Rights Framework, the Peace and Security Council is the organ that is responsible for implementing the right to peace. You will note that it has different structures, such as the Panel of the Wise and the Continental Early Warning System. I'll talk about the Continental Early Warning System because of the time. I cannot talk about the other structures. The Continental Early Warning System is designed to anticipate conflicts, prevent conflicts, right? But why is it that Africa is one of the region or continent that is ongoing wars? Like right now, Sudan, Ethiopia, Central African Republic, there are ongoing wars through and through. Yet we have a system that is supposed to anticipate and prevent conflicts and report to the African Union General Assembly of the potential conflict that may arise. My view is that this Continental Early Warning System is adopting a very minimum approach to peace because they're not looking at other aspects that trigger conflicts, such as social and economic issues. Unequal distribution of resources is one of the challenges that we have in Africa that leads to armed conflicts. So my view is that if this Continental Early Warning System would approach peace from a very broader point of view, it would help in terms of eliminating conflicts in Africa. Also, when we look at how the right to peace is framed, is implemented in Africa, particularly when you look at women's rights, you realize that it's viewed in terms of participation. Like Article 10 provides that women have a right to participate in peace structures, but the participation of women has also been minimum. There have been underrepresentation of women in a lot of these peace structures at the regional level. So that is also a problem. And it results in a lot of sidelining women who, in most of the cases, are vulnerable to violation of the right to peace. They are the majority of the victims of the violation of this right to peace. So my view, or in my thesis, my view was that, or my recommendation was that, let's look at peace from a very broad perspective, not looking at absence of physical violence, but looking at violence itself. How do you define violence? Let's broaden the definition of violence. Thank you. That will be all from me for now.
Thank you very much, Paida. It's very, very important. Before we will proceed with Elaine's presentation, I would like to thank those who have already sent their questions to Q&A session. It's very important. Please proceed. Please do not hesitate to send your questions, and we will do our best to accommodate all of them. So, Elaine, the floor is yours.
Thank you. Thank you, Elena, and thank you for organizing such a wonderful and timely panel. I think it's the first time in my career I make a presentation before such a broad audience. So it's, as my predecessor said, it's really a good sign. My presentation actually will be a bit different from the previous one, and I will adapt because I assume that among the participants there are practitioners. And especially one of the questions was asked about, if you fight for freedom, is it related to the protection of the right to peace and so on? So my presentation will be more how, from a litigation perspective and from a practical perspective, and how to, whether or not we have a standalone right to peace or rights that are around the right to peace or connected to the right to peace, how to make this right or these rights implemented and operationalized in a very concrete perspective, and how to build a case. You are a lawyer, you are indeed defending human rights defenders, a trade union leader, political opponent, and so on. Are you also defending someone, you know, who is protecting or defending the right to peace? So more focused on jurisprudence. Maybe a general remark before starting. Before the European Court of Human Rights, of course, you probably know that we have more and more cases, individual cases, but also interstate cases dealing with armed conflict, ongoing hostilities, transitional period, amnesty, and so on. So it's not completely new before the Inter-American Court of Human Rights, as mentioned by Cecilia. But for the European Court of Human Rights, of course, it's very well connected to armed conflict occurred on the European territory. But as you probably know, there's no right to peace in the European Convention of Human Rights. There's also no right to peace in the Covenant on Civil and Political Rights at the UN level. But actually, the question I would like to address is whether or not we need a standalone right to peace, or we could use, other rights already protected, civil and political rights, individual or collective rights, to achieve a peace agenda and to achieve the right to peace. I will just give you maybe four or five examples. First, all the jurisprudence, the case law, the complaints brought before human rights organs that are related to what human rights organs call a pluralist society. For me, they are related to the right to peace, or they are related to what other panelists called the positive peace. Because of course, in this kind of situation, when you have cases dealing with, for instance, pluralism and freedom of expression, pluralism and protection of civic space, but also religious pluralism, it has to do with the right to peace. And very recently, another report from another special rapporteur, very interesting report, was adopted on freedom of religion, pluralism in in religious context, and as a precondition for the right to peace. So if you fight for freedom of religion, if you fight for freedom of expression, peaceful assembly, peaceful protest, actually, to me, it's related to this positive aspect of the right to peace. Again, and I will not develop because that was already said, participation, political rights, for sure. I mean, it's also a precondition for achieving the right to peace. More importantly, of course, as you know, there are many cases dealing with hate speech, discrimination, stigmatization, intolerance, exclusion, and so on. It has to do with building a peaceful society. So here it's more, I would say, the negative aspect. So how to make sure that we have a peaceful society and that people do not exclude others just because of their singularities and so on. It's another way actually to litigate in favor of the right to peace, but of course it will be more framed as a non-discrimination case, or as a case dealing with hate speech, or a case dealing with intolerance, racism, and so on and so forth. On the more or less a bit different aspect, I think Cecilia mentioned safeguard, and indeed access to justice, or when when a situation of conflict is over and you have a lot of cases before human rights organs dealing with transitional justice, the right to truth, but also the memorialization. It has to do also with the right to peace and how to make sure that the restoration of a peace situation is really secured and is really maintained. Final point I would like to mention, I think it echoed just what presented about the African system. What we are seeing also emerging in the jurisprudence, it's very interesting. It's both the individual and collective dimension of the right to peace. So for instance, in the African Commission on Human and People's Rights jurisprudence, we have more and more development and jurisprudence on the right to security. And the right to security understood as the right of to live a life free from violence. So it's also something that has to be, analyzed or I would say, or monitored. And final reference, as you probably know, there is this pending case before the African Court on Human and People's Rights, DRC versus Rwanda, where precisely the right to peace, Article 23 of the African Charter, has been raised by DRC. So let's see where, because we do not have a decision on the merits so far, but the African Charter and the Maputo Protocol were raised. So let's see where the African Court would go in precisely providing a definition of, potentially definition of this right to peace.
Thank you very much, Hélène. Thank you very much to all of you for your insightful inputs. And we now proceed to our discussions. So questions from me, but I would like continue to encourage the audience to send questions to Q&A. Thank you very much to those who have done this already. So our discussions will be structured based on the past, present, and future of the right to peace. And let me introduce you some discourse and some excurse of the right to peace. The history of the struggle for the human right to peace reflects an ideological rift between the so-called Global South and the Global North. And there have been three major attempts to recognize the right at the international level. I mean, first and foremost, the Declaration of the Preparation of Societies for Life and Peace in 1978. It has recognized the individual and collective right to live in peace, but failed to acknowledge any corresponding obligations of actors. The second attempt was the Declaration of the Right of Peoples to Peace in 1984, which acknowledged a collective, also negative, we discussed this a lot already, right of peoples to peace along with corresponding obligations of states. And the most recent effort was the Declaration on the Right to Peace in 2017. It generated the most intense debates, during which the initial and quite comprehensive draft was replaced by a minimalist version that neither articulated the concept nor recognized the right to peace as a right. It replaced the collective aspect of the right with an individual one, and also switched from the concept right to peace to the right to enjoy peace. It is what mentioned by Surya, and failed to recognize implementation and monitoring mechanisms, moved many contentious provisions to the preamble or removed them while softening binding language, and so on and so on. So my first question to the participants would be, why, in your opinion, have these initiatives not led to the recognition of a legally binding human right to peace at the international level? And what lessons can be learned from this experience? May I ask Surya to address this question?
Thank you, Elena, for the question. In my view, recognition of a human right is a complicated process at the international level because all states may have a different view. In relation to right to peace, maybe many states have apprehensions that if this right is recognized as a human right, what obligations it will entail. For instance, in my view, disarmament will be a consequence of recognition of right to peace because more weapons do not really mean more peace. So if we recognize right to peace as a binding human right, then citizens will demand that why states are investing in more and more weapons rather than eliminating poverty and dealing with child labor ensuring climate justice. So, of course, there's a vested interest on the part of many states to avoid any litigation or anything of that nature. And of course, we have some states who have military bases all over the world, outside their territories of the countries. So if we recognize right to peace, it will have a direct implication for those military bases as well. So I think in the political context, there are several reasons, in my view, why states are resistant to the idea of a clear articulation of what is right to peace and what implications in terms of obligations it has. But let me conclude by saying this, Elena, that even if it is not recognized fully as a legally binding human right at the international level, we should still use the soft standards to promote right to peace as well as peace. So, because sometimes the hard standards at the international level are as ineffective as soft instruments. So, we should not go with this sharp distinction between hard human rights and soft human rights. Thank you.
Thank you very much, Surya. Paida, may I invite you to share your opinion on this question?
All right, thank you very much, Elena. My view on why there's been resistance by states to recognize the right to peace as in a binding treaty has been more, my view is that it has been more to do with the impact on the right in relation to interstate relations, not the individual collective per se, but the interstate relations. It has repercussions on what would the right to peace mean in terms of self-defense, in terms of issues of interference in another country to protect peace. This has been, I think this has been one of the resistance why states have been reluctant to view peace as a human right. And also the fact that what is peace itself is something that is very broad, it's amorphous, it's big, it's like an elephant. Because, and the other thing is that peace is not static, right? It changes with time. Like if we eliminate physical violence, if we eliminate conflict, can we say we are now peaceful? It's quite debatable. So what is this thing that you call peace? That's another element. The definition of peace itself, and also the issue of the effect that it may have to interstate relations. I say so because when you look at the communication that was brought before the African Commission, by DRC against Rwanda and Uganda, there was an issue that Rwanda was interfering in DRC, and Rwanda was saying we are protecting our interests. So in essence, Rwanda was defending its peace because they're saying you have got issues, we want to protect our interests. But Rwanda was also interfering in Uganda, in DRC. So those dynamics of interstate relations is, I think, is one of the reasons why we have so much resistance on viewing peace as a human right.
Thank you so much, Paida and Surya. And let me proceed with another question. It's actually very much connected to what you already mentioned and the question we have just discussed. So, is in your view important to recognize peace as a subject of a distinct human right? And if it is, why? In other words, do you think the right to peace have a potential to foster some peaceful and just legal and political order? Can peace contribute to the right to peace contribute to decolonization of the international legal system? And if I go even more specific, how could the right to peace empower vulnerable individuals and communities which live in conflict-affected settings, such as Myanmar, Ukraine, Palestine, Iran, Sudan, and many, many others? May I ask Cecilia to step in and try to answer this question?
Thank you. We absolutely need to consider recognizing the right to peace because of the pervasive normalization of violence around the world through the adoption of conflict management policies. The escalation of militarization is astounding, and the suffering and the damage in so many countries is frankly unacceptable. From a feminist perspective, there's no question that the right to peace is fundamental for women. We really take issue with the fact that it should be downgraded as some sort of secondary type of right. For us, we know that the right to life, the most important right, is contingent on the right to peace. So Vattel, a long, long time ago, wrote that the obligation of the sovereign is to guarantee peace to their people. That is what the sovereign is supposed to do, to enable them to have a happy life. And that obligation extends not just to their own people, but to other peoples. And this notion of a state obligation to show responsibility to maintain peace has been completely forgotten by states today. So that's why we need a right to peace, to remind them of the obligation. And at the negative level, the right to peace is the corollary to the prohibition on aggression. So people can call for accountability of state and corporate actors for complicity due to their capitalization in militarized economies, such as drone manufacturers, convoy operators, financiers, brokers, mercenary groups, etc. And civil society can demand audits of military transfers between states to identify the risks of complicity in atrocity crimes and gender-based violence and the targeting of civilians. In Costa Rica, we actually had a case where a law student just went and filed a case against the government for expressing support of the U.S. military action in Iraq, and the court upheld the law student, saying that this is correct and that support had to be removed from the website. So the expression of conscientious objection to war and violence is an important aspect of the right to peace. And at the positive level, civil society groups can demand that the state show transparency in budgeting to meet the obligations to dismantle structural violence by financing healthcare, education, and housing.
Thank you so much. I deeply appreciate your answer. Surya, would you like to continue with this question?
I agree with what Cecilia was articulating, but let me add a couple of minor points in terms of why this right matters. I think if we have a specific human right, and I completely agree also with other panelists, Helena, that we can see this right to peace interconnected or read this right into other human rights already. Yeah? So I definitely subscribe to that view as well. But if we have a specific recognition of this right, I think it would be very powerful for individuals and groups impacted by conflicts to demand redress. And that redress could be the guarantees of peace, the guarantee of non-repetition in the sense of one country not attacking another one because they suffer if the attacks are taking place. It can definitely entail reparation. But I would also argue that conflicts also pollute the environment, something we have not so far discussed in our webinar. So we should see the connections of conflicts with the environment, with climate change as well. So if we have right to peace, it will also have a bearing on creating more sustainability around us. And let me conclude by saying that we still have the situation of occupation. The Israel's occupation of Palestine territories is a good example of it. So we need to move away from decolonization in that particular sense, that wherever those occupations are taking place, they have to be eliminated as well. Thank you.
Thank you very much, Surya. Before we proceed with another question, I would like to again encourage those who have questions but have not just yet sent them to us. Please do this. We're gonna address them, and many thanks to those who already have done this. My next question would be about extensive criticism which have been voiced in debates surrounding the right to peace. And my question is, in your view, which critiques is the most relevant, and how this critique may contribute to the development of the right to peace? Paida, may I please ask to address this question?
All right, thank you. There have been a lot of criticism by scholars, practitioners on why peace should be recognized as human rights. I think one of the main criticisms is that peace is a very broad concept, and it can be looked at from a peace can be like an umbrella that covers everything, right? Such that the peace itself, or the right to peace itself, can be protected by the already existing rights, such as the right to life, the right to security, whether it's state security or personal security, the right to equality, the right to participate, the right to dignity. So the criticism was, should we have another right when that right itself can be protected by already existing rights? When I look at that criticism, yes, it holds a lot of water, but I think we can still move from that criticism and advocate for the right to peace to be stand-alone right, in the sense that what we call other rights that are covered by peace can also be the underlying determinants of the right to peace. For example, the issues of right to life, issues to do with personal security, issues to do with state security, issues to do with participation, equality, those also can be considered to be underlining determinants of the right to peace from a collective approach or from an individual approach. That would be my view of this.
Thank you very much, Paida. And I would suggest us to move rather to a present situation, present approaches to understanding the right to peace. And I would kindly ask each of you, one after another, to share your understanding of the right to peace, including its nature, relationship to other rights, its content, key elements, and scope. Please be brief. Hélène, would you be happy to address? Thank you.
Yeah, I will be extremely brief because I feel a bit, I'm the skeptical of the group because, and thank you, Paida, for highlighting the criticism. Actually, that's my criticism on the recognition of the right to peace as a standalone. I'm still struggling with as a lawyer, with the added value. And actually, my impression, with all my due respect, my impression is that in our discussion, there's a sort of confusion between peace as a condition or precondition for, human rights, peaceful society, and living together and so on, and the right to peace. So I definitely agree when we talk about violence against women, when we talk about protection of climate change. There were also some questions about protection of children and so on. I definitely agree that peace is a precondition for effectiveness of human rights. But maybe I'm too conservative, and maybe, I'm focused on civil and political rights, but also economic, social, and environmental and cultural rights. But I still do not understand what will be the added value. And the reason why I do not understand, and I even think it would be very dangerous because it's very broad, it's very vague, it's for some reasons Paida mentioned a bit earlier, what is the scope? Do I have the right to international peace, or only to peaceful relationship with my community or in my country and so on? I mean, there are absolutely complex legal questions we would need to address to do a proper job and to do a serious job. So I cannot answer your question, Elena, sorry, about the scope, the content, and so on, because I'm still not very clear. Even on the right holders, whether it's an individual right or whether it's a collective right. When we talk about the right for women, for instance, the right to live a life free from violence, it's not in this international perspective. It's more, okay, I have the right to be protected against the violence of my partner. So yeah, I think we still have to work a lot to plead for the legal recognition of the right. That's my position.
Thank you very much, Hélène. Actually, you did answer both questions, the previous one and this one, because we do need criticism, and criticism is something which gives us a material for further development. Without critique, you cannot progress. It's my understanding, but we have answers from other participants as well. And may I ask Surya to proceed?
Okay, so let me be brief. I think Helena has made a good point that there's a lot of ambiguities there are about this right, potential right, or actual right. Definitely, peace is a precondition as well. So I don't see it either or. So peace is definitely as a precondition for all other human rights, to development, to anything else that we need: environmental protection, climate justice, gender justice. But we can also see, from my perspective at least, the value addition of recognition as right to peace. Is this a broad right? Yes, but many other rights are broad. I will argue right to life is so broad that we don't need any other human right, because right to life can include everything else: housing, water, privacy, speech, assembly, peace, and everything. So why do we need any other human right? So this objection that right to peace is a broad, ambiguous right applies to many other human rights, which are very well established under international human rights law. My second point is the value addition may come when we're talking about participation of people who is benefiting from conflicts, who is benefiting from war economies, who is benefiting from attacks that are made against other sovereign countries and all this. So people should be able to demand that participation in some way. And you can see in the Constitution of US that the president has to go back to the Congress. You can see that that is in a way some kind of a checks and balances. Of course, in practice, it's not working, especially under the current president. But we can see that connection, that if we have the right to peace, then people will be able to demand that accountability of the decision makers about peace and conflict. Thank you.
Thank you very much, Surya. Cecilia?
Yes. Well, first we have to distinguish between justiciable and non-justiciable rights. So not all rights recognized at the international level are justiciable. And peace, the same with solidarity, they're not given justiciability at the international level. That is to be determined by each state or regional system. So if the African Union wants to say that the right to peace is justiciable, that's great. But the other regions are not compelled to do that. If Colombia wants to recognize it as justiciable, that's also acceptable. But the Declaration on the Right to Peace doesn't give it justiciability. So what it does is it sets peace as an enabling right, that everyone has the right to enjoy peace, such that all human rights are promoted and protected and development is fully realized. It's an aim. It's not intended to be justiciable. But what it sets forth in the Declaration is that states are then given a soft obligation that refer to the elements of positive peace, as well as two of Roosevelt's four freedoms: that they should respect, implement, and promote equality and non-discrimination. There you have your positive peace elements. Justice and the rule of law is in there, and guarantee from freedom from fear and want as a means to build peace within and between societies. So it can be domestic and international. And this recognition enables states to actually articulate that they need to address structural violence and exclusion. And all people should then have access to housing, education, healthcare, and jobs, and an adequate standard of living. So you can use this articulation to say that states should promote alternative dispute resolution for community disputes, in labor disputes, to promote peace education, as they do in Peru. And then you can even argue that the freedom from fear can argue that the state has an obligation to avoid nuclear destruction. So the limited language in the Declaration is actually expansive and very inspirational. It is intended to be inspirational. It's not intended to be justiciable.
Thank you so much, Cecilia, for your opinion. Paida, some input from you?
Yes, thank you very much. I think I'll ride on from earlier submissions by Surya on the fact that all rights are broad. They are very broader, but it's up to us to determine how we can interpret them, right? In terms of justiciability, as Cecilia just said, so that peace does not remain an aspiration, but something that is justiciable, that you can be litigated upon with underlying elements and the entitlements that are very clear on the rights holders in the state and the duty bearers. My understanding, if I'm to follow up on the right to peace, if I'm to advocate for that, would be we need to define peace as the absence of violence. But our issue now would be to broaden what we define as violence, because that has been the limiting factor. Absence of violence, whatever violence in its form, structural violence, and does it include, when you look at women and children, intimate partner violence? Does it look at social and economic violence? It has to be broadened so that we define, so that at the end of the day we come up with elements of what elements that constitute the right to peace. In relation to its interdependence with other rights, yes, I agree. Peace is interrelated with a lot of rights, such as right to life itself, right to development. If you look at peace from a collective point of view, right to development is also, I wrote a paper where I say the right to development is the other coin of the right to peace, right? A right to development, we look at right to equality and non-discrimination, right to dignity. So one of my recommendations in my thesis was that I proposed the elements of the right to peace, and I argued that, let's say, participation, right? Because participation enables people to define what they view as peace. Let's emphasize on participation. Let's emphasize on equality. Let's emphasize on human dignity. Those three aspects, to me, will assist in terms of implementing these rights if we take into account those three aspects: participation, equality, and dignity.
Thank you very much, Paida. We need to proceed to one more question, and this is about actually corresponding obligations of states and non-state actors. I have a fear to ask Elaine, who is skeptical about the right, what will be these corresponding obligations to the right, but please try.
No, I try, but the more I listen to the colleague, actually, the more I see the contradiction between, because some said, okay, it's just a source of inspiration, and others said, okay, let's discuss about justiciability and equality, dignity, and so on. But we have already, rights in favor of equality, dignity, and so on. So again, I mean, in terms of states and non-states, so I will maybe narrow down, because some of the questions were about, arms, military bases, and so on. So let's be practical, because I love theory and I love philosophy, but if we want to also give, a sense to our discussion, let's also explain concretely what it would mean to have a right to peace. And one of the questions raised by Elodie Tranchet was, do we as individuals, for instance, have the possibility to go in court and to contest the engagement of war? But the very same question could be raised on arms transfer and so on. So here, indeed, I see where, where states' obligation, but also non-state actors' obligation could be developed in terms of arms transfer. But we have already, a treaty dealing with arms transfer and human rights obligation. So I would, designing this obligation, I would definitely go in that direction. There was also, and I stop there, there was also a very interesting proposal, I think, by another speaker to talk about the obligation to create a peaceful environment. But again, same question. Is it my peaceful environment, very close to me, my family, my work environment, and so on? Or do I have the right to live in a worldwide peaceful environment? That's still the question I have. And again, what we have to check is more this development of litigation dealing with the engagement of war. So I answered to Elodie that in some countries like Germany, indeed, the decision to go at war is justiciable, but also all this litigation dealing with arms transfer in Israel and so on and so forth. So yeah, that would be my skeptical answer.
Thank you very much, Hélène. Surya, as an expert in business and human rights and obligations of non-state actors, could you please address the question of corresponding obligations of state and non-state actors, which would be derived from the right to peace?
Thank you. I think if we have to articulate obligations, first of all, we need to articulate better, more precisely the contours of this right. And if we recognize this human right as a justiciable human right, I think it has to be articulated in a narrow sense, in my view, to make sense of the obligations. And I think that would be the absence of armed conflict, armed violence, in my view, in the collective sense. From that particular perspective, the obligations on businesses would be in terms of how, let's say, the AI or other automation companies are developing weapons for conflicts. So, and how they produce, how they supply those weapons, that obligation of private actors will be triggered. Because war economies, the beneficiaries are significantly companies and the investors who are investing in those companies. So the obligations in terms of production, export will be there. The issue of transparency will come into picture. The right to information will be engaged as well to support the right to peace in those particular situations. But also the questions about the taxpayers' money being used to fight wars, and what is the goal of a war? I think there's one question about in relation to can there be a war or a conflict to protect human rights? Because sometimes the duty to protect is invoked, the responsibility to protect is invoked to start a conflict. So I think that issue also has to be grappled with. So what are those contours within which a state can invoke the intervention? And are these interventions justified? Are these principled? Are these consistent? Because there's significant amount of political selectivity in those interventions as well. Thank you.
Thank you very much, Surya. We mentioned already several times the role of courts in promoting the right to peace, and I have a special question about that. So I would like to invite you to tell us a little bit more about the role of courts in interpreting, developing, and implementing the right to peace. May I ask Cecilia to intervene? Thank you very much.
Yes, both national and international courts are intrinsic to the right to peace because they promote peaceful dispute resolution. But if we turn to the international level, the Inter-American Court addressed peace in Ober Dictum in the advisory opinion on environment and human rights because they said that there was a risk of violation of the right to peace due to the environmental displacement of the community and the possibility of violent conflict with settled communities. In addition to this is the cases I mentioned before on non-repetition orders regarding non-discrimination and equality in cases involving women, refugees, minorities, indigenous people, and they do call for restitution of property in the context of displacement. They address territorial boundaries, and they actually call for training of immigration, border guards, police, and medical staff and military in non-discrimination. But they've also issued decisions quashing amnesty laws that prevent accountability and issue provisional orders calling for protection of judges and journalists and trade union activists and environmental activists and human rights defenders. At the African level, the Commission had two cases involving Article 23 on peace, and the first one, it had to do with the duty of non-intervention and the obligation of Pacific dispute resolution. And in the second, it looked at the legality of the use of embargoes in relation to the military coup. I'm actually waiting for someone to please file a case on the African Protocol on the Rights of Women, Article 10.3, which places an obligation on states to take the necessary measures to reduce military expenditure significantly in favor of spending on social development. This is ratified by 44 states, so I hope it happens. And at the African Court, we also have another case involving violations against civilians in Mali committed by the Malian armed forces and the Wagner Group. And this one establishes Mali's responsibility for abuses committed in its territory and its failure to prevent the violations, protect civilians, and investigate and prosecute and sanction those responsible. So that's super exciting. So we have a lot of movement there.
Thank you very much. We are a little bit in a hurry, and I would kindly ask Elaine and then Paida briefly address this question, but really briefly. Thank you so much.
Yeah, thank you very much. So for me, the role of the courts, regional, universal bodies, but also domestic tribunal, is precisely to leave this very abstract and philosophical, debate and inspiration, peace as an inspiration element, to give a concrete meaning of the different element and the scope of states' obligation and so on. But I just also would like to briefly reply to a question by Mikiko Otani. So I'm really happy she's following. And she asked me whether my skepticism is similar to, recognition of the right to a healthy environment. And actually, I had at the beginning the same kind of skepticism. But now I'm fully convinced that we need a standalone right to a healthy environment for different reasons. The reason why we need a right to a healthy environment is because precisely the international human rights framework is not developed enough to address environmental and climate change questions. So, I mean, we have to go further precisely because what we have is not enough to duly protect the right to a healthy environment. I have not heard from the different perspective that what we have in international human rights law is not enough to cover participation, equality, non-discrimination, development, and so on, when we talk about the right to peace. So that's where, I would still resist. But thank you for raising the point.
Thank you so much, Paida, about the role
All
of
right, my view is that the role of the courts is to create jurisprudence, interpret the provisions of the statutes, and give conclusive and give clear entitlements of these rights. But for that to happen, we need to have litigants that take the matter to court, and we should have access. One of the challenges to the African Court is access itself by individuals, by non-governmental organizations to bring cases before the African Court on Human People's Rights. Just like Cecilia said on Article 10.3, it would be one of the most interesting provision that should be brought before the African Court. The issue of reducing military spending in favor of social spending for women. It should be one of the provisions that should have been brought. But then we've got limitations in terms of access to the court itself. So the cases that have been brought before the African Commission relates to interstate communications. But again, the Commission has not pronounced itself on what the right to peace means. They only found a violation to say Rwanda violated the right to peace. But what is it that what does the right to peace mean? So as long as we don't have interpretive judgments by the courts, the right to peace remains a vague and somehow flawed legal concept. So we need jurisprudence to be created by the courts, but then we need litigants that move the courts to do so.
Thank you so much. And I would like to ask the final question in the discussion, and then we will proceed to Q&A. I cannot avoid the question about the future of human rights, meaning the human right to peace. And my question is, what steps should be taken to advance the recognition and implementation of the right to peace? What are the prospects of this right to receive finally international recognition as a legal right, and what institutional arrangements are necessary for its realization? May I briefly, very briefly, within half minute or maximum minute, ask to address this question, Hélène and then Cecilia? Thank you very much.
Oh, I think, so I will be very brief because I think there's an excellent answer in the chat. So Boumediene Benaya actually proposed for me something that is excellent. Let's move from the theory and philosophical concept to something that is much more, he suggests to go, in a much more normative dimension, and to develop the effective legal normativity. That's, I have to, again, to be very frank, for me, that is what is still lacking. So thank you, Mr. Benaya, for responding the question directly and based on your work.
Thank you so much. Cecilia, what about you?
Yeah, we need, at the international level, we need a serious campaign to demand respect for the UN Charter, Article 2, 3, and 33, that sets forth an obligatory sequence of pursuit of nonviolent dispute resolutions before the use of force. We have had the opposite practice, and it's been disastrous for the whole world. At the local level, I do believe in building the peace from the ground up, so that just like we have departments of war, I support the Italians who have ministries of peace. Every country should decide for itself how it's going to approach peace and address those policies that will help it within its own societies and build it up.
Thank you so much, Cecilia. Well, with that, we proceed finally to Q&A. Maria, the floor is fully yours. Thank you very much to all those who sent their questions. And yes, Maria, please.
Hello, hi everyone. First of all, I want to thank Elena for organizing this wonderful panel. I want to thank all the panelists and the attendees. Yes, the number is scary, I have to admit as well. I also admit that I come also from the critical perspective of the so-called right to peace during the last year that I'm working on that, being in the Department of War Studies. And while I was following your discussion and also the Q&A, I would say that I have identified a couple of threads, common threads of critique, of concern and questions. And the first one is what I would call the oxymoron of the invocation of peace. So there were a couple of questions trying to link in the name of peace, such as we say in the name of humanity, with military interventions or with the further violation of other human rights or protection of human rights by violating peace. And this question is very much linked to, I would say again, the oxymoron between the global security architecture and what human rights want to achieve. Do you identify a tension there between what we have within the UN Charter, the Security Council, and the so-called right to peace, not peace the way it is described within the UN Charter? So that's the first, I would say, cluster of questions. The second cluster of questions is very much related to what you addressed now, and it's about the future. And there were some participants who actually asked, what should the civil society do? How more actively should be the civil society? And here I would add, given the political momentum, I'm not going to go into the debates about the death, crisis, backlash of the international legal order, but how do you see the role of the civil society? What is the imagination, if you want the legal imagination we need? The third question, the third cluster of question again is very much about the concreteness of the proposition. Elaine already responded to the need for justiciability. Surya, you mentioned redress, and I think that was very well taken by some participants, like concrete, that it can trigger the right to redress, to non-repetition, or to climate change. And here, Surya, there is a particular question addressed to you also. Can you see the right to development without peace? And do I have another? No, I think that were the three main clusters. I hope I didn't miss anyone. It was impossible, but I tried to group them into clusters of questions. But I would insist also on the political momentum. How do you see that, given the fact that from one side we had all this discourse about the fatigue of human rights, the very much hesitation, even hostility to human rights? Can we trigger a backlash, an unintended backlash? Thank you very much, Elena, and all.
Thank you very much, Maria. Let me suggest as our speakers to address the aspects they would be interested in addressing. Surya, can I ask to start with you, if possible? Would you like a particular question to be repeated, or it's enough the summary which Maria has just delineated?
I mean, there are several specific questions that are posed. So let me try to react to some of those questions. There was one question about diplomacy, that can diplomacy be misused? And I will say diplomacy, good faith is a precondition for diplomacy. So diplomacy has to be pursued in good faith. And if we pursue this in good faith, then diplomacy can be a key role in preventing conflicts and sustaining peace. We need to follow early warning signs. I was just reading some weeks back a book by the son of the former UN Secretary General. And the book is called Peacemaker. And in that book, Peacemaker, he highlighted how the UN Secretary General Thant played personally a key role in diplomacy to avert conflicts. So in my view, diplomacy can definitely play a key role if it is done in good faith and following the key principles of the UN Charter. So that is, let's say, one reaction to my point. There was another specific question about right to development and peace. And of course, my report that will be out hopefully in a month's time or so will articulate that connection. But it is widely accepted that there is a nexus between peace and development, which is also part of the three pillars of the UN system. But I will say, and I think that's where I will try to, let's say, build on what Helena was saying, that we need to make a distinction between peace as a precondition and peace as a human right. Peace as a precondition is a very broad concept. Peace as a human right, in my view, at least, it has to have a narrow contours. And then it will trigger specific obligations on states and non-state actors. That is about, let's say, going to war, going to establish peace. That will go into how much we spend on military. These are the questions that will flow directly from recognition of right to peace. But of course, without peace, I think it's almost impossible to realize right to development. If you look at the military expenses, $2.9 trillion were spent almost last year. So if we invest so much, and we have complete peace in the world, I will think this strategy works. It's a worthy investment. But if after investing so much, we have the highest number of conflicts, then this is not working. And that's why we need to go away from more weapons approach. And doing so, we need to invest in development, sustainable development, inclusive development. That will be a better strategy in my view. Thank you.
Thank you very much, Surya. May I ask Ellen, which have already done a lot of work responding questions. So please, very briefly, to have some more time for the other participants. But thank you very much for your contribution. Yes.
Yeah, no, there was just maybe one very interesting question also by Mr. Amadou Sidi Diallo about whether, so question 2, to what extent the right to peace could be considered as customary international law. I'm skeptical about, the recognition as a part of customary international law. So I don't think so. I don't think we can consider it's part of a customary international law. Again, I mean, except if we have such a level of abstraction that we would consider, but no, based on the practice and the state of international law, I would not go in that direction.
Thank you so much. Paida, may I ask you to proceed with picking your aspects of question and answering them?
Yeah, my issues, I would comment on 2 issues on what can be done by civil society and practitioners in terms of advancing the right to peace or recognizing the right to peace. I will speak from an African perspective where the human rights system has recognized the right. So from an African perspective, I would say organizations that have access to the court by observer status, by having observer status before the African Commission, should litigate on the rights, bring cases before the African Court on Human and People's Rights so that we have jurisprudence. My second comment would be on the relationship between the right to peace and the right to development. Again, speaking from the African experiences, where the continent suffer from a lot of foreign investments in the name of development, where foreign companies come in to undertake projects that disrupt the life of indigenous communities, thereby violating the right to peace in the name of right to development. So I would think there is a need for a balance on that, on development, and also recognizing indigenous communities' right to peace within the context of development itself. So my view is that the right to development and the right to peace are totally interdependent, especially if you're looking at it from the collective right perspective.
Thank you so much. Thank you so much, Paida. Cecilia, you are the last, answering the last question.
Thank you. I just want to underscore that the concept of peace as a corollary to the prohibition on aggression, it gives it the quality of erga omnes. So peace should be given the respect that it is due as an aim for the orientation of all states around the world. And the concept of the right to peace is the engagement of society reaching towards that Grundnorm. So the conscientious objectors in Germany, you're calling for conscription, and you have all of these young Germans who are filing for conscientious objection. They don't want to participate. This is important. If you read my report on solidarity, you will see so many civil society groups that are engaging in peacemaking every day, and they're invisible. They're not in the media, they don't get any attention, but there they are trying to construct peace from the ground up. So I am actually optimistic. I think that this wave of militarization and violence around the world is not normal. I think that we just have to make spaces for recognition of the engagement of civil society, and we have to call into account both state and corporate actors who are pursuing violence against the interests of people around the world.
Thank you so much. Many thanks to everyone who asked questions. If we were unable to address all of them, well, it's because there were so many, but we did our best. And I will share the rest of the questions with the participants. They might contact you, or they might contact you through me. So, and in any case, what your contribution is very important for us. So we need to proceed to our final closing remarks, unfortunately. And I will give the panelists and to you, Maria, 1 final minute to summarize what urgent steps should be, from your perspective, taken to efficiently advance the right to peace. In case of Hélène and Maria, it looks like to officially advance human rights, which promote peace. Okay, let us proceed like that. So may I ask to start with Hélène.
Advance human rights to promote peace. No, more seriously, again, we have to clarify. We need clarity, because from what I heard, I mean, there are so many different perspectives that I have the impression that even in our group, there's no consistency in the way peace is conceived or the right to peace. So I would go for clarity and and the promotion of the right. And I think Maria mentioned this. I think it's important also to keep in mind this human rights fatigue. Maybe I'm influenced by this human rights fatigue, and this, we have to really take this seriously. It might be counterproductive. So yeah, I take the conservative position, and but I would definitely plead for clarity in what we are pleading for.
Thank you so much. Paida?
My parting shot as a proponent of a right to peace, despite its legal flaws, I would say it's still possible for us to recognize peace as a human right at international level, despite its legal flaws. What is required maybe is to start from a minimalist approach. Let's view it from a minimalist approach of elimination of armed conflicts. Maybe from that, we start from that, and then we build up and include other aspects of positive peace. That way, it will be possible to come out with the entitlements and the duties of duty bearers and the entitlements of the right holders.
Thank you so much. Surya?
I will build on what colleagues mentioned, that definitely we need more clarity in terms of the elements of the right to peace as a human right. And that will then result in articulation of obligations of states and non-state actors. We'd also need to put more emphasis on the implementation of this right at the national level, in my view. So because international law, even if we recognize this, even in a binding covenant, let us say at the international level, ultimately the question is of the enforceability and implementation. So I would like to devote more energy at the national level, at the regional level, in concrete operationalization of this human right. What does it mean in practice? In my view, we should be focusing more on that. Thank you.
Thank you so much. Cecilia?
Peace education. I live in a country that used to be at the top 10. Now it dropped because of its military budget. But a crucial aspect of why it was in the top 10 is because peace was taught in schools, and children were taught to respect each other in spite of differences and to engage in conciliatory aspects to dispute resolution. We have to start from the young generations up to change the culture and create a culture of peace for everyone. So I would go back to working with schools.
Thank you so much. Maria?
Thank you. A couple of years ago, in the Venice Biennale, there was this exhibition in the Peruvian pavilion called "Peace is a Corrosive Promise." And peace is very important. So I would say I agree with what all the colleagues said. And I would say we need to be careful and cautious in order the so-called right to peace to remain a promise of hope and not a corrosive promise. Thank you.
Thank you very much. I'm so happy we are in time. This is my last minute. So I am very grateful for your participation. I'm very grateful to all the fantastic questions which we received. I'm grateful to our director, Nilüfer Oral. I'm grateful to our wonderful events team and Jerry. And you know what? I'm so grateful that you approached the right to peace from such diverse perspectives. I believe this is fundamental to arrive at something which we really can call universal. Without underlying diversity, universality is just impossible. And I have learned a lot personally. My deep belief is that the right to peace is essential for promoting peace, for decolonizing and improving the international legal order, and for empowering the most vulnerable individuals and society. And I do agree with everyone who mentioned that it is a very uneasy fight for the right to peace. But I believe that the fight for the right to peace is absolutely worth it. So thank you very much again to everyone. And please join our next webinars generally from CIL, but particularly those which I will be organizing on various aspects of human rights. We will be organizing together with Ellen. Yeah, so, and we are waiting for you, and we are very grateful to everyone who have joined us tonight, despite of variety of time zones. And yes, I'm very grateful. Thank you. And smile.
Thank
Jerry
you.
asked us to smile.